grounds of divorce. Divorce. So here there are certain grounds wherein you can ask for the divorce, wherein the agreed party can ask for the divorce. Any marriage, whether solemnized whether before or after. See the wordings of this section. This section is also have application retrospectively and also prospectively. Whether before or after the commencement of this act may on a petition presented either by the husband or the wife be dissolved by a decree of divorce on the ground that the other party, now the grounds are mentioned. That so first subclass, subsection 1, clause 1, wherein it is mentioned that has after the solemnization of marriage, had voluntarily sexual intercourse with any other person other than his or her spouse. So if a person who is having a extramarital life, that is who is having who had sexual intercourse other than with the spouse, so that will be a ground. So whenever a person alleging this ground, the burden of proof heavily lies upon the person who is alleging that my spouse, that is the other party, is in extramarital relationship with someone else, and who had also had an extramarital intercourse with the other person. So in this case, they have to prove it strictly with all the proofs. So that is one of the ground. So having extramarital sexual relationship with other person is a ground, other than the spouse, is a ground for the divorce. Now coming to subsection clause 1A. He has after the solemnization of the marriage treated the petition with the cruelty. Here it was mentioned that cruelty. So the cruelty may be by words, that is mental cruelty and physical cruelty. For physical cruelty, there will be certain some sort of evidences like the scars on the body. The person is treated with some cruelty, like we can prove it. The physical cruelty, we can prove it. But for the mental cruelty, it is very difficult to prove. It has to be established by the circumstantial evidence and by producing the oral evidence. But the best witnesses to this cruelty is that husband or the wife. So here, in this case, the cruelty is not defined anywhere under any act. So it depends upon the person to person. It depends upon the case to case. So for example, if a person A is a wife, B is a husband. So A is a woman who has been brought up in a very high profile family, and she has lived her life in a very lavish manner. So she marries to a person who is a monthly salaried guy. Meanwhile, while the marriage life is going on, they have some disturbances between the two. There are some differences because of the lifestyles. So for a person who has brought up in a high profile family, the respondent is unable to provide that kind of status, that kind of family lifestyle to that woman. And apart from that, treating her with negligently or doing something else against her will give some kind of cruelty to the person who has brought up in a high profile family, wherein because there will be no day for her to sleep with hunger, and this kind of things will be there. So depends upon case to case and facts to facts, the cruelty is defined. Even Supreme Court and different high courts of our India, nowhere it is defined that this is the cruelty and this has to be followed. There is no measurement for cruelty. The cruelty is defined, and they has to be independent as to different each case. It is independent to the each case. So now Now we are going to the desertion. Desertion, that is class 1B. So here has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of this petition. So here we can see, so where a person deserting the another petitioner. So if A is a husband and B is a wife, so the wife deserts husband, leaving the conjugal life, leaving the matrimonial life without any plausible ground, that is reasonable ground. She left the husband and she lives separately for more than 2 years. For more than 2 years. So for more than 2 years, there is no cohabitation, there is no consummation of marriage, there is no intercourse between the two couples. So that will becomes a ground. Leaving apart for more than 2 years is a ground which can be bring into the desertion. So to file a petition under this act, there shall be the mandate time period is 2 years shall be separation. That is a thing which we have to be noted, keep in mind before making an application. Now coming to subclass 2, class 2. Who has converted into another religion? If a person who has converted into another religion, for example, A and B are Hindus by the time of marriage. B is the husband who converts into Christianity without intimation or without information to anybody else. Now he becomes a Christian. So now the marriage automatically, now this case, conversion into another religion becomes one of the best ground to get the divorce from the court. Get the divorce from the court. Next, coming to a person has incurably of unsound mind or has been suffering continuously and intermittently from mental disorder or of such kind, and to such an extent the petitioner cannot reasonably be expected to live with the petitioner. So here, if a person is suffering with incurable mental disorder or incurable unsoundness of mind, or incurable, that means which is unable to cure. So in these cases, it will definitely cause us hardship to another person. So considering this and taking this ground, this is the unsoundness of mind as a ground, we can file a petition for divorce. Now coming to person has been suffering from a virulent and incurable form of leprosy. So leprosy, which is incurable form, is also a ground for filing a divorce petition. Now, and another one is venereal diseases in a communicable form. Venereal diseases means the diseases which will spread when two persons came into a physical contact. So when these diseases, when a person, either of the spouses is suffering with the venerable diseases which is in a communicable form, that means spreading in a spreading form. So that contaminating and spreading form. So that is also a ground which is a incurable disease. That has to be noted. So the disease shall be incurable disease, venereal disease in a communicable form is also a ground for seeking divorce. Has renounced the world by entering any religious order. So here, so sannyasam puchukovam antaru. Renouncing the world means sannyasam puchukovam. So oka vyakti, either A or B, a wife or husband, renounces the world by accepting by accepting some of the religious orders. So if any of the person becomes sannyasi, so the other spouse, that becomes a ground for other spouse to file the divorce petition. Next one. If a person has not been heard for a period of 7 years or more by those persons who would naturally have heard of it had that party been alive. So here this is a provision which is related to Indian Evidence Act also, that is section 107, 108. So wherein it was, it was discussed that if a person is not heard for more than 7 years, it is a presumption under the law that it is presumed that the person is dead, presumed to be dead. So this has been taken and it has been incorporated here. If A and B, if B is a person who went for some traveling to the world trip like that. So he went there, he went like that, but he has not returned for more than 7 years, and his presence and his whereabouts were also not known to any of the persons. So in that case, that that also a ground for taking divorce from the court of law. Now there is an explanation that is mentioned in section 13. In this subsection, the expression desertion means the desertion of the petitioner by the other party to the marriage without reasonable cause and without the consent or against the wish of such party, and includes a willful neglect of the petitioner by the other party to the marriage, and its grammatical variations and cognate expression shall be construed accordingly. So the explanation, they have mentioned what should be a desertion, what shall be a desertion like that. So wherein, so without any reasonable cause and without the consent of the opposite party and against the wishes of the other partner of the marriage, some person willfully neglecting them and leaving separately from the one person, one partner of the marriage, one spouse. So that has to be considered as a desertion. Now coming to subsection 1A, either party to the marriage, whether solemnized before or after the commencement of this act, may also present a petition for dissolution of the marriage by a decree of divorce on the ground that there has been no resumption of cohabitation as between the parties for the period of 1 year or upwards, whether the passing of decree for a judicial separation in the proceedings to which they were parties. So as we discussed in section 10, so judicial separation, if there is no cohabitation between the parties for 1 year or more, then it will becomes a ground for the judicial separation. I mean, it will becomes a ground for the divorce. Now coming to subsection 1A clause 2. So that there has been no restitution of conjugal rights as between the parties to the marriage for a period of 1 year or upwards after passing of the decree for restitution of conjugal rights in a proceeding to which they were parties. So as we discussed in section 9, so even after passing a decree of restitution of conjugal rights, if either of the party against whom the order is passed fails to comply the order of the court to join the conjugal company of the another partner, definitely that amounts to a ground for the seeking the divorce to the party who has got the conjugal restitution of conjugal rights order. Now this section 13 subsection 2 is specifically for a wife. These grounds are only for the wife who is intended to file the dissolution of marriage, that is divorce. So in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of the husband married before such commencement of act was alive at the time of solemnization of the act. So this section, this specific clause is similar to the essential conditions of the marriage, section 5 subsection 1. So this section also says that if for example, as we discussed, prior to 1955, there is a polygamy, that is a male marrying 2 or 3 wives, more than one wife. So in that case, if a woman marries that person who is having a spouse, after this enactment, she can seek for divorce. Prior to this amendment, since there is no provision for the woman to take divorce, so there were many women who was lived like that and spend their life. But the woman who wants to come out of the relationship, like who doesn't want to be a second wife, who doesn't want to be a third wife, she can file a petition under this section 13 subsection 2. So saying that he is already having a woman in his life and he married to me as a second wife, so I want to come out of the marriage. That is the ground for this. That will be the ground exclusively for the woman to come to file for the dissolution of the marriage. Now coming to the subsection 2 of subsection 2, clause 2 of section 2, that the husband has, since the solemnization of the marriage, has been guilty of rape, sodomy, and bestiality. So if the husband is guilty of offense under section 375, 376 of Indian Penal Code, and bestiality and sodomy, which are the unnatural sexual offenses. So if he is guilty of these kind of offenses, it becomes a ground for the wife to seek the divorce. Now coming to section class 3 of subsection 2 of section 13, that in a suit under section 18 of Hindu Adoptions and Maintenance Act, or in the proceedings under section 125 of Code of Criminal Procedure, or in the proceedings in section 125 Code of Criminal Procedure, a decree or order, as the case may be, has been passed against the husband, awarding the maintenance to the wife, notwithstanding that she was living apart, and that since the passing of such a decree or order, cohabitation between the parties has not been taken place. So here, if an order is passed, that is section 18 deals with the maintenance of wife. Section 18 of Hindu Adoptions of Maintenance Act deals with the maintenance of the wife. If the wife gets an order under section 18 or section 125 of CRPC, if the husband fails to comply the order and they live separately for more than 1 year, without compliance or without compliance of the order, they are living separately, then that also becomes a ground for the wife to file the divorce petition before the court of law. Next, that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she has repudiated the marriage after attaining the age, but before attaining the age of 18 years. So here, this specific provision is relating to section 6, during the situations of the child marriages where it were happening. So in that period, if the bride is of 15 years or less than 15 years of age, if she came to know that marriage is that the marriage was performed against her will and wishes, so during that time only she has reported. That means she has not accepted the marriage, knowing that marriage was the child marriage, or that was against her wishes. Then she can file the petition under this act after attaining the majority. She has reputed the marriage after attaining that age, but before attaining the age of 18 years. So this, as per this section, she can file the petition before 18 years itself. So that is clear from the wordings. That means that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years. And she has repudiated the marriage after attaining that age, but before attaining the age of 18 years. So before attaining the age of 18 years, she has to make an application before the court to take the divorce from the court of law against the marriage. So that is section 13, the grounds of section 13. So there are common grounds for husband and wife, and there are certain specific grounds that are mentioned in subsection 2 of section 13. Section 13. Now coming to section now we will discuss about section 13A, alternative relief in divorce proceedings. Alternative relief in divorce proceedings is suo motu powers that is granted to the court, or you can make an application. Or the court can grant suo motu orders under section 13A. That is alternative relief in divorce proceedings. In any proceedings under this act, on a petition for dissolution of marriage by a decree of divorce, except in so far as the petition is founded on the grounds mentioned in class 2. Subclass 2. That is that we can say that is a conversion into another religion, and class 6, that is renouncing the world, and class 7, that is not heard for 7 years. Of subsection 1 of section 13, the court may, if it considers it just so to do, having regard to the circumstances of this case, pass instead a decree for judicial separation. So if the court feels that the judicial separation will help the spouses, will help this marriage institution and to continue further, the court can order the judicial separation, except in the cases where where that is when the party, when the spouses have renounced the world, when either of the spouse has converted into another religion, and when this when either of the spouse is not heard for 7 years. So except in those cases, the court can order for judicial separation for 1 year summatively or by an application by the parties. Now, coming to that is the alternate relief in divorce proceedings. So the court feels that there is a possibility of reunion or something else. So the spouses to the marriage, they can live together and they can live. So then if the court feels fit, then it will order the alternate relief of judicial separation in the divorce proceedings. Now coming to this section 13B, which is a trending divorce in the current Indian Indian society. That is divorce by mutual consent. Divorce by mutual consent. Subject to these provisions, that means the only that thing which we have to remember in this subsection section 13B is, so a divorce by mutual consent. That means both the spouses to the marriages files an application by arriving at understanding that they are going to dissolve the marriage. So there will be no any kind of undue influence or duress or something, coercion or something on them. So they come to the court filing the application that there is no possibility of reunion of the marriage and there is no possibility of living together. So then in those circumstances, both the petitioner, that is husband and wife, or the petitioners in this case, there will be no question of respondent in this case. Both the parties come to the court, files the petition seeking the divorce by mutual consent. So mutual consent, in this mutual consent, the essential condition is both the spouses shall be living separately for more than 1 year from the date of from the date of issues. That means the essential condition, the precondition for filing this petition is 1 year separation is mandatory. And second thing is, in this case, when subsection 2 that was discussed in subsection 2 of 13B, it was discussed that after application of the parties, there will be a period of 6 months period that is called cooling off period. Cooling off period will be there in this case after filing the mutual divorce by mutual consent application before the court of law. Why the cooling period is? The cooling period is the chances that are given to the spouses. If there is any possibility of reunion, then that will be cooled off. So at the time of filing the petitions, at the time of disputes between the parties will be under the heated situation, so that there will be no chance of reunion. So because of this cooling period, there is a possibility of reunion, and the parties may come down and they may think of their relationship, and if they want to continue, they can proceed with the relationship. So that is the purpose of giving this cooling period. So after this 6 months, after the 6 months, after filing the petition or presenting the petition to the court, 6 months time will be given. That is the cooling period. From that is the 6th month date, a date is given. From that date to 18 months, within 18 months, the petition has to be disposed of. So that is the time limit that was mentioned in this section 13B with regard to the divorce by mutual consent. Even in many of the cases also, this 6 months cooling period has been waived off by the courts. It is only an option that is mentioned, but that can be waived off by the parties by presenting a petition to the court seeking that there is no possibility and there is no chance of reunion. There is no possibility and there is no chance of reunion. That is the situation. And even recently, the Andhra High Court also said that the 6 months cooling period is a mandatory but not directory. So that period can be waived off if the parties, if there is no possibility that the marriage is going to reconcile or reunion. The marriage between the parties is going to reunion. Now,